Okay, we're going to get started. So welcome and thank you for joining us for this SulmeyerKupetz webinar. My name is Hami and I'm here with Jessica Vogel. We're both attorneys at SulmeyerKupetz, which is a boutique firm in downtown Los Angeles specializing in all bankruptcy and insolvency related matters. So the title for this webinar is indicated on the slide on the screen is Purchasing Bankruptcy Estate Assets, Rewards, and Risks. One of the reasons we chose this topic is because sales are really an integral part of bankruptcy cases. And in fact, many bankruptcy cases, specifically Chapter 11 cases, are filed primarily, if not exclusively, to facilitate a sale of assets. Another reason we chose this topic is because I find that a lot of non-lawyer investors are kind of intrigued by the idea of buying assets out of a bankruptcy case, out of the perception, and which is not necessarily unfounded, that you could get a great deal if you buy them through a bankruptcy case. So we put this webinar to address this area of bankruptcy, and this topic really could span several webinars. It really has a lot of material to cover, but we really designed this for non-bankruptcy practitioners to provide an introduction and an overview of the process of buying assets through bankruptcy and to identify some of the more common benefits and risks or downsides to buying assets out of bankruptcy. Before getting into the details, on the screen is a summary of what we plan to cover over the course of this presentation. So we're generally going to cover the following areas. First, we'll start with a discussion of the bankruptcy sale process, procedures, and requirements for selling assets in a bankruptcy case. Next, we'll get into some of the main or more common benefits of purchasing assets through a bankruptcy. And finally, we'll discuss some of the risks or unfavorable aspects of purchasing assets through bankruptcy that prospective buyers should know going in. So let's start with the process, procedures, and requirements involved in selling assets through bankruptcy. And actually, one comment before we move on, although the procedures and process is really stuff that the bankruptcy lawyers would be dealing with, we included this in the webinar because we think it's still important for potential buyers to at least have some general understanding of the process as they venture into the bankruptcy, into buying assets out of a bankruptcy case. The sales of bankruptcy assets could proceed through one of two avenues depending on the chapter in which the case exists. If the case is a Chapter 7 bankruptcy case, the assets could be sold during the case pursuant to Section 363 of the Bankruptcy Code, which is the statutory predicate for allowing a sale of assets. If the case is one under Chapter 11, the debtor, or if a trustee is appointed, there are two options available. First, you could sell the asset also again under Section 363, just like in a Chapter 7, or you could also sell the assets through a Chapter 11 plan that the court confirms. And I should note that we divided these different means of selling assets as between Chapter 7 and Chapter 11, but it's not meant to state that sales could only occur under these two chapters. Sales also could proceed under other chapters of the code, but the focus of this presentation really is going to be on sales in Chapter 7 and Chapter 11 cases only. So as I just indicated, Bankruptcy Code Section 363 is the particular code section that governs sales of bankruptcy assets, and it divides sales into two categories. First, you have sales in the ordinary course of a debtor's business, and second, you have sales that are not in the ordinary course of a debtor's business. And this divide is designed to strike a balance between, the need to allow a debtor to smoothly continue with its regular operations post-bankruptcy, and on the other hand, the need to protect assets from being dissipated by the debtor improperly so the assets ultimately could be used for the benefit of creditors. So let's first take a quick look at how bankruptcy deals with ordinary course sales. So Section 363C1 of the Bankruptcy Code deals with ordinary course sales. If a proposed sale of an asset of the bankruptcy estate is in the ordinary course of a debtor's business, the debtor could proceed with the sale without the need for notice to creditors, without a hearing before the bankruptcy court, and without any court approval. the authority to sell the asset under those circumstances is granted by the statute itself. So using the stereotypical widget company hypothetical, a company that sold widgets before it filed bankruptcy could keep selling widgets after bankruptcy, and it could do so without providing any notice to creditors and without any court approval. Now, there's an entire body of case law discussing how the determination is made regarding whether a particular transaction is within the ordinary course of business. Now, this is somewhat beyond the scope of this webinar because we're really going to be focusing on sales outside of the ordinary course of business, but I'll touch upon it really because it is important from a buyer's perspective, because if a particular sale is outside the ordinary course of business but was not noticed to creditors or approved by the court, the buyer runs the risk of having the sale unwound. So very briefly, courts have developed two tests for determining whether a transaction is in the ordinary course of business. First, you have the horizontal dimension test, and second, you have the vertical dimension test, which also is sometimes referred to as the reasonable expectations test. The horizontal dimension test looks to similar businesses as the debtor's business and determines whether the transaction at issue is one that would normally be entered into by a similar business. So it's really just trying to see if the sale at issue is abnormal or unusual for this industry. The vertical dimension test looks at the transaction from the perspective of creditors and asks whether the transaction is one that creditors would reasonably expect the debtor to enter into. So under this test, even if a transaction that might be ordinary in this specific industry, it may still be deemed out of the ordinary course for this particular debtor. So for example, if the debtor is a small business selling widgets, the sale at issue may still be considered out of the ordinary course, even if it involves the sale of widgets, if the particular sale is unusually large for this specific debtor. So that's all for ordinary course sales, and now we're going to move on to non-ordinary course of business sales, which is really the focus of this webinar. So non-ordinary course sales are governed by Section 363B1 of the Bankruptcy Code, and it provides, that subsection provides that the trustee or a debtor in possession, if it's a Chapter 11 case, after notice and a hearing, may sell, other than in the ordinary course of business, property of the estate. So all this means is that in contrast to a sale in the ordinary course, when the sale is outside the ordinary course, the debtor may not sell the property without first providing creditors with notice and obtaining court approval for the sale. As noted earlier, the differing treatment between ordinary course and non-ordinary course is designed to strike that balance between the interests of the debtor and its creditors. On the one hand, again, it allows the business to continue operating smoothly without excessive court oversight after bankruptcy is filed and without the added administrative costs. And on the other hand, it protects creditors from the debtor dissipating assets improperly. Non-ordinary course sales could be of either just a portion of the debtor's assets, or sometimes it could be a sale of all or substantially all of its assets. Now, one reason a debtor might want to sell only specific assets is to shed assets that are either weighing it down or no longer necessary for the debtor's business or too expensive to maintain. So, for example, a debtor might want to sell specific equipment or a specific operating unit or subsidiary if that unit or subsidiary is no longer profitable. Another reason for selling only certain assets in any given sale is that the debtor may believe that separate sales may yield more money than if the assets were sold as a single unit. So even though in the end the debtor may end up selling all its assets, it may do so in sort of piecemeal fashion if it thinks it can net more than if it sold it all at once. On the other hand, sometimes the reverse of many of these same reasons apply, and a debtor may decide to sell substantially all of its assets. So, for example, the debtor may believe that the sale of all of its assets would yield more than if it sold it in piecemeal. And sales of substantially all of assets, usually you see those in mid to large size Chapter 11 cases. Non-ordinary course sales could also be either public sales or private sales. And the primary difference is that a public sale is, as the name connotes, is open to the public and will be sold through an auction between qualified bidders, and we'll get into what that means a bit later. On the other hand, a private sale would not be open to the public and would not be subject to overbid. Now, private sales are more difficult to justify than public sales. They're more difficult to justify to the court because presumably in a private sale, the asset was not necessarily adequately exposed to the market, and by not being subject to overbid, may not necessarily garner the highest and best price for the estate. And that's important because maximizing value for the estate is really a primary goal in any bankruptcy case. But that does not mean that private sales are per se barred. They are not. And usually they occur under one of three circumstances. First, it could occur when a debtor needs to move quickly and the delay in marketing a particular asset to the public would result in complete loss of any value of the asset. Second, it could happen when a debtor is unlikely to get any better offer than it already has. And third, a private sale could be justified if the specific type of asset does not have a large pool of potential buyers, so it really wouldn't be efficient to spend the time and resources to market the asset to the public. Finally, in addition to public or private sales, sales in a bankruptcy case doesn't necessarily have to be to a third party or to an outside third party. The sale could be to an insider, such as a shareholder of the debtor. But an insider transaction will be subject to higher scrutiny to make sure that there's no collusion or fraud, because sales to insiders often are more susceptible to fraud or collusion than to a third party. And the sale also still has to be the product of an arm's length negotiations, which means, for example, that the parties should have either independent counsel or independent brokers or agent negotiating the deal, and the price would still have to be a fair price. So that's the kind of general background of the types of sales, and I'm now going to turn it over to Jessica.
Okay, so now I'm going to talk about the actual sale process. As Asa mentioned, a sale of an asset outside of the ordinary course of business through Section 363B requires court approval. And the standard for obtaining court approval of such a sale requires that the bankruptcy court find that the sale is fair and reasonable. Now, fair and reasonable, as borne out by case law, has come to mean that the sale must be supported by a sound business reason and based on a sound exercise of business judgment, which is a fairly deferential standard to the seller, so the trustee or debtor in possession, and really means that as long as the seller can articulate some legitimate reason for wanting to sell the asset, a court will typically approve the sale. Another sort of subcomponent of the fair and reasonable standard is that the sale must also be in good faith, which really focuses the bankruptcy court's attention on whether the asset is being sold for fair value. If the seller is going to receive fair market value for an asset, then there's less cause to question the integrity of the transaction, and that goes back to what Asa was talking about, the difference between a public auction versus a private. And courts generally agree that the marketplace is the best indicator of the value of an asset. So most 363 sales occur through a publicly noticed auction in order to satisfy this fair and reasonable standard and price requirement. Conversely, a court is likely to find that the sale is the product of bad faith or misconduct if the court detects some kind of collusion between the seller and buyer, or really any attempt to take an unfair advantage of other potential purchasers to influence the price in any way, influence who the ultimate purchaser is going to be. Now, another requirement for obtaining court approval is the process is that the seller must give creditors and other interested parties appropriate notice of the sale and be afforded an opportunity to file an opposition or response. Now, typically, at least here in the Central District of California, notice of the motion must be served on all creditors with 21 days notice prior to a hearing that is selected by the seller. And the notice must include the essential information about the sale, such as the time and place of any public auction. If the sale is a private sale, then the terms and conditions associated with that sale, when objections and responses are due. Okay, like most sales outside of bankruptcy, the seller and buyer, typically referred to as a stalking horse buyer in bankruptcy, will negotiate what's called an asset purchase agreement that sets forth the terms of the parties' agreement and specifically identifies the asset or assets to be purchased, as well as the sale price. In addition, if the buyer seeks to acquire an operating business or commercial or residential real property with existing tenants, as a few examples, then the asset purchase agreement would typically also indicate whether the buyer intends to assume or reject existing contracts and leases. Preparation of this asset purchase agreement occurs outside of the bankruptcy court and before any motion to approve the sale is submitted. And then it is attached as an exhibit to a motion to approve the sale that then gets filed with the bankruptcy court for review in connection with the motion itself. So if the court approves the sale, the court will then issue an order, a sale order, which together with the asset purchase agreement will outline the requirements, conditions, and timing for closing. Okay, so moving along in the process towards a public sale at an auction, the seller now has its stalking horse bidder and has negotiated its asset purchase agreement. The stalking horse bidder's price establishes the floor price for the asset, with the offer to then be tested by the market through an auction process. So the next step would be for the seller or the seller's broker to continue to market the asset to attract other interested buyers and qualify them to bid at the auction. To provide guidance to potential bidders and ensure fair bidding and overall auction process that can be approved by the court, the seller will propose certain bid procedures and requirements for bidders to qualify to bid. Now, the bid procedures are subject to bankruptcy court approval, which could either be obtained before the bidding process and auction by submitting a motion to approve bid procedures and getting the court to approve that, or it could be approved on a nunc-pro-tunc or retroactive basis by asking the court to essentially simultaneously approve the proposed bidding procedures at the same time the court is considering the sale motion itself. And the bid procedures will identify, among other things, the time and place for the auction, the deadlines for submitting bids, the qualification requirements to participate in the auction, the minimum overbid amount, and the increments in which bidding will occur at the auction. So generally just what everyone can expect in the lead up to and during the auction. Now, the size and complexity of the transaction usually will dictate the extent and rigor of the requirements to qualify as a bidder. And typically, these requirements are going to be something like submitting a bid at a certain identified minimum price that is higher than the stalking horse bid, providing a minimum deposit to the seller for the seller to hold pending conclusion of the auction, providing evidence of financial wherewithal to consummate the sale at the submitted bid amount or some higher amount in the event it's anticipated the auction will go up. So this would require submitting a bank statement or some kind of letter from a bank with a commitment of financing. And finally, usually evidence that the bidder has no insider or other connection or relationship to the parties involved. And this is designed really to avoid the risk of collusive bidding, which we'll talk about later. Okay, so once bidders have been identified and qualified to bid, the auction can proceed on the date pre-selected by the seller. Now, there are no specific requirements in the Bankruptcy Code as to where an auction must take place, but the most common places are before the hearing to approve the sale motion at a location outside of the courthouse. So, for example, this could take place at the counsel's office if it's a sale of a business, or a piece of equipment at a company. It could take place on the business's actual site location. And then once the auction is concluded and the successful bidder has been selected, the seller will then get that sale approved at the sale hearing by the court. Another option for an auction is that it could take place at the sale hearing itself, but off of the record, for example, out in the hallway or in a conference room. And finally, it could take place at the sale hearing itself on the record before the bankruptcy judge. Now, I'll note that the best option really for all parties is to have the auction take place on the record so that there is a recorded transcript of exactly what transpired during the auction. The transcript would then be essential in the event any issues arise down the road concerning bid amounts, good faith purchaser findings, or whether there was an affirmative commitment by anybody to serve as a backup bidder. Okay, so let's talk about what qualifies as the successful bid, because the best bid is not necessarily going to be the highest price bid that's submitted. Instead, the seller, again, this is a trustee or a debtor in possession, really has the discretion to determine which bid is the highest and best bid, and accordingly, which bidder will be deemed the successful bidder. Now, depending on the needs of the estate, certain bids may have a lower cash component, but include other considerations that make that bid more attractive to the bankruptcy estate than a bid with a higher cash price. An example of this would be a bidder might agree to assume certain unattractive leases or agree to release certain claims against the estate. And again, that may be a more attractive and better result for the estate than just getting more cash. So the seller will evaluate the bids received and will then announce which bid it believes is the best overall bid. Now, selection of the successful bidder does not necessarily mean that the other bidders have no chance of acquiring the asset. Instead, other bidders usually at the sale hearing, or if it's not at the sale, during the auction or at the conclusion of the auction, they will have the option to indicate that they'd like to remain on as a backup bidder. The backup bidder is usually the bidder who submitted the second highest and best bid, and then that bidder would be next in line to close the sale at the last bid that backup bidder submitted in the event the successful bidder fails to close for any reason other than the seller's default. The caveat, however, is that agreeing to be the backup bidder means that that bidder's deposit is going to remain on the hook and will be forfeited if the backup bidder also fails to close for any reason other than the seller's default, and will typically be tied up at least until the successful bidder closes the sale in the event that that occurs. But I should note that there is no limit to the number of backup bidders, and it's actually better for the seller to have more backup bidders in place because successful bidders often fail to close for one reason or another, and so having the protection of a backup bidder or multiple backup bidders will avoid the seller having to go through the entire sale process all over again. Okay, so you've heard us talk about sales of bankruptcy assets in Chapter 7 liquidation and Chapter 11 reorganization cases through Section 363B of the Bankruptcy Code, which really makes up the bulk of bankruptcy estate sales. But now I'm going to highlight the very basics of a sale through a Chapter 11 plan. Now, the first thing to know is that the goal of a Chapter 11 case is to confirm a plan that dictates which claims the debtor will pay, how much it will pay on those claims, and the means of making those payments. And the means of making those payments often involves the sale of some or substantially all of the debtor's assets. In order to sell an asset through a Chapter 11 plan, the debtor must actually confirm a plan. And when we look to the Bankruptcy Code, there are two separate sections that contemplate implementation of a plan through a sale of assets. The first is Section 1123A5D, which provides that a plan may be implemented through the sale of all or any part of the property of the estate. And the second is Section 1123B4, which provides that a plan may provide for the sale of all or substantially all of the property of the estate and the distribution of the proceeds of such sale among holders of claims or interests. Although plan confirmation is fairly complicated and it's a sophisticated process that goes well beyond the scope of this webinar, the basic process involves the debtor proposing a plan that then gets distributed to creditors to vote on. If the debtor obtains enough votes in favor of the plan and the court finds that the debtor has satisfied a number of requirements laid out in 1129 of the Bankruptcy Code, then the plan will be confirmed. And what this means is that a sale through a Chapter 11 plan does not require direct court approval of that sale. Instead, if the debtor is able to obtain the necessary votes in favor of its plan and satisfy the plan confirmation requirements, then the proposed sale, which is usually described as a provision or a mechanism to implement the plan, will be indirectly approved as a component of the overall plan. However, as part of the court's review of the overall plan, the court will usually look at the merits of the sale price, and the seller's marketing efforts. Okay, so that's the basic process for selling an asset through a 363 sale and through a Chapter 11 plan. To recap, each involve different procedural requirements. As previously discussed, 363 sales require satisfaction of the fair and reasonable standard and a finding of good faith, and typically takes place over about a month to 2 month period. Sales through a Chapter 11 plan require confirmation of the plan, which requires satisfaction of a host of plan confirmation requirements. And these types of sales typically take place over a much longer time frame, and as a result, usually, but not always, involve larger and more valuable assets of the debtor's estate. Now, aside from the procedural differences, sales through a Chapter 11 plan will often involve the same basic process as the 363 sale. This means that the seller and buyer will still negotiate an asset purchase agreement, which will be subject to the ultimate review of the court and creditors. Another difference between a sale through a Chapter 11 plan and a 363 sale arises in the context of obtaining a sale free and clear of existing liens. In the case of a 363 sale, the debtor is required to satisfy one of 5 conditions set forth under Section 363F of Bankruptcy Code, which Asa will discuss a little bit later, in order to have the sale be free and clear of existing liens. And the purpose of 363F is to protect lien holders from being wiped out in a bankruptcy proceeding from a one-off sale. Now, where a debtor is unable to satisfy 363F, a debtor could instead propose through a Chapter 11 plan the same sale, and that way it avoids needing, the seller or debtor avoids needing to satisfy one of the 363F requirements in order to obtain an order authorizing the sale free and clear of all liens. And this is because plan confirmation requirements contain so many protections for lien holders already, and specifically afford lien holders the opportunity to vote on the plan, that lien holders are essentially validating or approving the sale free and clear through the ballots that they cast. Okay, the last difference worth noting between Section 363 sales and sales through a Chapter 11 plan is that a buyer can avoid paying transfer taxes if the sale is done through a Chapter 11 plan, but would not also be able to do the same thing through a 363 sale.
Okay, thanks, Jessica. Now let's talk about some of the primary benefits or advantages of buying assets out of a bankruptcy case. And to be clear, when we're discussing these benefits in this presentation, we're really doing so from the perspective of a prospective buyer of assets. And there are generally between 4 to 5 main potential benefits for a buyer purchasing assets out of bankruptcy. And a brief list of those potential benefits is on the current slide on the screen. And we'll go through each one separately. So the first benefit is that, as Jessica kind of briefly went through, is that you could buy the assets free and clear of existing liens. And this is by far the most oft-cited benefit to a buyer out of bankruptcy. And this is governed by Section 363F of the Bankruptcy Code, which is the code section that authorizes sales free and clear of, quote, any interest. And the breadth of scope of any interest is subject to interpretation by varying courts, but it certainly includes existing liens. And some or all of debtors' assets may be subject to various types of liens, including, for example, liens of secured lenders or judicial lien holders. And while the presumptive rule in bankruptcy is that any sale of a debtor's property is subject to existing liens, a buyer typically will want the assets only if the purchase is free and clear of those liens. So in that regard, this is obviously also a benefit to the bankruptcy estate, which otherwise perhaps will not be able to sell these assets to anyone. Now, the liens don't just disappear. They would attach to the proceeds of the sale to the same extent, validity, amount, and enforceability as they existed as against the property just before the sale. But as far as the buyer is concerned, they do go away, and they're no longer the buyer's problem once the sale closes. So long as the sale fits in within one of 5 circumstances that are laid out in Section 363F of the Bankruptcy Code, the sale could proceed free and clear of the liens. And again, those 5 circumstances are summarized on the slide, and we'll go through each one one by one. Now, the first 2, I think, are self-explanatory. The first scenario under which assets could be sold free and clear is if there's some non-bankruptcy law that would have allowed the seller to sell these assets free and clear of a particular lien, then in that case, the seller in bankruptcy could rely on that non-bankruptcy law and use it to sell the asset free and clear of that lien in a bankruptcy sale. And the second scenario is simply if the lien holder consents to the sale. And the only thing really to note is that some courts hold that a lien holder's failure to oppose a sale after getting notice of the sale could be deemed consent to the sale. Now, the third circumstance is if the interest at issue is a lien and the selling price is greater than the aggregate value or quote value of all the liens on the property being sold. So, for example, if the purchase price is, let's say, $7 million and the total amount of liens is only $5 million, then the sale could proceed free and clear of liens. Now, there's some variance in the case law as to what is meant by the term in the code section to the term, quote, value of the liens. There are some courts that base this analysis on the face amount or the actual outstanding amount of the liens. And there are other courts that say that value should be defined as the secured value of the lien, not the face amount. So to use the same example it's above on the slide, this means that if the face amount or total amount outstanding under all the liens is $5 million, but the property is only worth $4 million, the sale still could be free and clear even at a price lower than $5 million, because those courts would hold that the value of the liens is not more than the value of the property, or $4 million in that hypothetical. The fourth circumstance under which a sale free and clear could proceed under 363F is if the lien, but again, not necessarily the claim, is in bona fide dispute. Under such circumstances, the sale could go forward free and clear of that disputed lien, with the lien to attach the proceeds of the sale subject to later resolution of the dispute. As indicated in the language of the statute, the dispute must be bona fide, which means that it has to have some reasonable basis or some validity to it. And an example of a bona fide dispute is if the lien arose under circumstances that would make it subject to avoidance under the trustee's bankruptcy avoidance powers, such as a lien that was placed on the property or the asset under fraudulent circumstances, or if it arose within the 90-day pre-bankruptcy preference period. The fifth and final circumstance under Section 363F that would permit a sale free and clear is when the secured party could be forced to accept a monetary satisfaction of its interest in a, quote, legal or equitable proceeding. Now, courts are split on what the phrase legal or equitable proceedings includes. There are some courts that hold it only includes proceedings that exist outside of bankruptcy, such as, for example, foreclosure proceedings or receivership proceedings. But there are courts that hold that it also includes proceedings that exist within the context of a bankruptcy case, such as what are known as cram-down proceedings involved in plan confirmation hearings, under which a secured party could be forced to accept payments under a plan to satisfy its lien. Now, the second category of benefits from a bankruptcy sale is that the sale will be approved by the court. And I think this benefits the seller in at least 3 different respects. First, it means that there will be court oversight over the whole process, and this ensures that the process is fair and involves no collusion or fraud. And it also ensures that any objections to the sale and the process are addressed at the outset to avoid any later problems or challenges to the sale down the line after it may be a bit too late. The second benefit from having court approval is that court approval means that you're going to have a court order finding that the sale was for a fair price and or fair price under the particular circumstances. And this is important because, as a general notion, recipients of assets, especially from a distressed entity, which a company filing bankruptcy obviously is, are always exposed to liability for receiving a fraudulent transfer. Now, because the sale occurs under court oversight and requires court approval, the court will deem, or obviously should deem, that the sale price was fair and equitable, and the court would find that the sale was conducted in good faith overall. This should shield the buyer from any claims that the sale was fraudulent or was a fraudulent transfer for insufficient consideration. Now, on that note, any buyer should make sure that the court finds and includes in the order that the buyer purchased the assets in good faith under Section 363M of the Bankruptcy Code. That provides an additional layer of protection to the buyer in the event of an appeal of the sale that we'll discuss a bit later in this webinar. Now, the third benefit of having the court approve the sale is that it makes sure that there are no issues down the line if someone asserts that the sale was outside the ordinary course of business. So as we noted earlier, if a sale is within the ordinary course of business, it does not need to be approved by the court. But if it's outside the ordinary course, it does require court approval, and if that approval is not obtained, the sale could be unwound later. So getting the court's approval of a sale avoids the risk of a later challenge to a transaction as being outside of the ordinary course without court approval. The third category of benefits to a bankruptcy sale is the ability to acquire assets for a good price, something obviously every buyer loves to do. Now, it should be emphasized again that the goal of a sale in bankruptcy is to maximize value of an asset, which means achieving the highest and best price. Therefore, presumably, purchasing an asset out of bankruptcy does not necessarily mean the buyer gets a great deal, and in fact, it really should mean that the buyer is paying what it would pay outside of bankruptcy, which would be the market price. But the phrases, quote, value and, quote, maximizing value really are tied to the circumstances. So often you have a debtor's assets that are referred to as a melting ice cube that must be sold immediately to achieve some value from the asset. So, for example, if the debtor is facing loss of an asset to foreclosure, or there's some substantial cash shortage that threatens complete shutdown of the business, the debtor may need to sell the asset right away, even if it's at a significant discount, or otherwise it could risk complete loss of the asset or complete loss of value for the asset. And under those circumstances, the seller would proceed with a fire sale, which necessarily results in a reduced price for the asset, and the buyer could and should try to negotiate an extremely favorable deal under those circumstances. And in fact, in that case, the buyer may even be able to negotiate a private sale rather than a public sale and avoid having the asset sold at an auction and risk not being the winning bidder and not getting the assets. Now, a buyer obviously should use those circumstances to its advantage and to try to get a valuable asset at a bargain price. The fourth class of benefits is something that Jessica mentioned earlier in discussing the differences between sales under 363 of the Bankruptcy Code and or a sale under a confirmed plan, and that's the ability for the seller for the sale to be exempt from the avoidance transfer from transfer taxes. But as mentioned earlier, that only applies if the sale occurs under a confirmed plan. And the fifth and final category of benefits that we identify applies only to stalking horse bidders. And there really are two advantages to being a stalking horse buyer. And again, the stalking horse is the buyer that first negotiates the sale with the trustee or the debtor in possession. And so there are two advantages to being the stalking horse bidder over being a bidder that comes in later to try to overbid. The first benefit is that the stalking horse buyer negotiates the terms of the sale with the trustee or the debtor in possession. And as we discussed earlier, the bankruptcy sale would involve a purchase agreement that is approved by the court as part of the sale. And that agreement is negotiated between the seller and the stalking horse buyer. So that means that the stalking horse buyer will actually have a say in the particular terms of the sale beyond just the price. And that's really a critical difference between the stalking horse buyer and other bidders, because the other bidders really come in later to the action and would be required to simply sign on to the existing purchase agreement, except for the price, that the stalking horse already negotiated. So in other words, the other bidders would be signing on to an agreement that someone else negotiated. And obviously, it would be better to have been a party to the negotiations to try to get some of the terms that you want into the deal. The second advantage to being a stalking horse bidder is that the stalking horse could negotiate a breakup fee into the deal. This is a fee that the seller would pay to the stalking horse bidder if the stalking horse is not the winning bidder at the auction. It's a fee designed to cover the stalking horse bidder's fees and expenses incurred in connection with any due diligence leading up to the sale. Now, the the breakup fee would need to be approved by the court, usually as part of the bidding procedures. They often are approved on the notion that it's the stalking horse bidder's commitment to the sale process that led to the auction with the other bidders and that ultimately helped the estate get the best and highest price for the assets. And the breakup fee needs to be reasonable and usually ranges from between 1% to 3% of the total bid amount. Now, again, this is a benefit that other bidders don't have, so even though the other bidders also would be incurring the costs of due diligence and attorney's fees, depending on the size of the transaction, if they lose and they don't get the assets, they would not be able to recoup those expenses as a stalking horse buyer would through a breakup fee. All right, now this brings us to the end of the potential benefits. And now we move on to identify some of the potential risks of buying assets out of bankruptcy and how to try to mitigate some of those risks. And we've identified 8 categories of potential disadvantages to buying assets out of bankruptcy, and they're laid out in summary fashion on the slide in no particular order, and we'll go through each one. So as we discussed earlier, an out of the ordinary course sale will be subject to court approval. And while we identified that as a benefit to buying bankruptcy assets, there also are some downsides to this, especially when the buyer is not the stalking horse. So there are two main downsides to court approval. The court approval process, and both stem from the fact that in the end this is a judicial proceeding, and 2 of them are laid out on this slide, and we'll talk about each one. So the first downside is that the court approval process could be expensive. For example, with a sale subject to notice and a hearing, you could have an aggressive creditor that's opposed to the sale, and although rare, they may try to subject the prospective buyer to discovery. This would require the buyer to sit for deposition. It also could end up requiring the buyer to testify at an evidentiary hearing in court, depending on the nature of the objections raised. This all likely would require the buyer to employ counsel, which of course could be expensive. In addition to those added costs, this also could be time-consuming for the buyer. Now, again, a stalking horse bidder may be able to recoup some of these costs as part of a breakup fee, but the other bidders would not have that protection. And even as to the stalking horse, they would only get the breakup fee to defer those costs if they're not the winning bidder. If it ends up being the winning bidder, it would not get the breakup fee, and these added costs really would just be part of the overall cost of buying the assets. So prospective buyers should have all this in mind when negotiating a price for the assets. The second downside from the sale being part of a judicial proceeding is the delay. With all the requirements, the notice period, and the right of the parties to object, depending on how contested the matter is, the process could be dragged out and the closing could be delayed beyond what the buyer may have originally expected or wanted. If there's a real need to expedite the matter, however, the seller could request a hearing on shortened time or otherwise try to persuade the court to expedite the process. But absent that, there always is this risk that the process drags out longer than the buyer otherwise desired. The second potential risk or downside to a bankruptcy sale is that once you are committed to the process, you need to go all the way or you risk losing your deposit. For example, if you tendered the deposit to the trustee and you participated in the auction and now you are either have been identified as the successful bidder or you agreed to be the backup bidder, which would be memorialized in a court order, if you later decide you want out, you will end up forfeiting your deposit. Now, it's true that this may also be the case in sales outside of bankruptcy, but it's a bit different in bankruptcy for probably two main reasons. First, outside of bankruptcy, if you later decide to back out, you could always try to negotiate a withdrawal from the agreement and try to minimize your losses and maybe even negotiate a return of some or all of your deposit. In the bankruptcy context, however, because the court is involved and third-party creditors are involved and a bankruptcy estate is involved, the trustee or the debtor in possession is a fiduciary of the estate and cannot just unilaterally agree to return your deposit or allow you to back out. Rather, the trustee probably would need to go back to court and potentially fend off further creditor opposition, or if the trustee doesn't do this, the buyer may need to hire counsel of its own and go to court to seek relief to try to recover its deposit if it believes it has grounds to. All this would not necessarily be required, or wouldn't be required with a sale outside of a bankruptcy or outside of a judicial proceeding. The second reason that this is different than non-bankruptcy sales is that whereas a buyer in a bankruptcy is fully on the hook, the seller in bankruptcy or the trustee usually could back out no consequences. So many, and in fact many trustees include language in the purchase agreement that allow them to back out no consequences other than returning the deposit to the buyer. Now this is true even if the deal is, this will be true even if the deal is already approved by the court. The court order approving the sale usually just, quote, authorizes the trustee to execute the transaction. It does not necessarily compel the trustee to go forward with the sale. And it's easier to include some level of protection against this in the non-bankruptcy context to make sure that the seller goes forward with the sale than it would be in the bankruptcy context. The next category of risks in bankruptcy sales is the fact that these sales are subject to overbid, which means they go to auction. And this creates some disadvantages. First, the nature of an auction is that some buyer necessarily will be outbid. This means that after expending time, money, and resources, and perhaps even hiring a lawyer, you could be outbid and will not end up acquiring the assets. Now, again, if you are the stalking horse buyer, you would have some recourse through the breakup fee, but that is only available, again, to the stalking horse. Second, the nature of auctions is to bid up the price as high as possible, and the auction dynamic sometimes causes people to bid more than they otherwise would pay for an item. And you really see this in situations when the various bidders know each other. For example, you could have bidders that are competitors of one another trying to acquire a business in the industry, or you could have two shareholders that are hostile to one another, and the asset for sale are the shares in the company, which would mean control over the company. In those types of cases, animosity or sometimes egos get the better of people, and they could end up bidding much higher than they ever contemplated. The fourth category of risks or downside is that all bankruptcy sales are as is, where is, with no reps and no warranties. This means that as a buyer, you had really better do your due diligence before jumping in. And the problem is that sometimes, depending on the circumstances, you may not necessarily have a lot of time to conduct the type of due diligence you otherwise would have liked to, and you end up only discovering problems after you are the winning bidder and it's too late to back out. So you really should do whatever due diligence you can as a buyer. Those are the first four categories of potential downside. I'm now going to turn this back to Jessica to talk about the remaining few risks.
Okay, so the fifth potential risk we've identified is the potential for collusive bidding. Now, to be clear, collusive bidding is not permitted and subjects colluding parties to serious liability. However, as I assume you could guess, this does not always stop people from colluding. And collusion can take a number of forms. So, for example, you might see bidders colluding with one another, or a bidder may collude with an insider of the debtor or the debtor itself to secure a better deal for themselves. Now, the motivation behind collusion could be that the debtor insiders want to artificially drive up the price. One or more bidders could try to force other bidders out to ensure the acquisition of an asset by a certain bidder. Or the motivation could simply just be to punish other bidders by forcing them to pay more for the asset, which could arise in the case of, for example, a stalking horse bidder who is upset about losing an asset after expending significant time negotiating the asset purchase agreement, conducting due diligence, and waiting for the sale process to reach the actual sale hearing and auction part of the sale process. The sixth risk we've identified is the potential for delay and increased expense as a result of uncooperative parties. When considering the fact that bankruptcy is typically a last resort for most debtors and often an emotional and traumatic experience, it really shouldn't come as any surprise that debtors and insiders are often resistant to having their assets sold by a trustee or having to part with assets themselves for prices that are lower than what they believe the assets are worth or that they have some kind of emotional attachment to. And in such instances, debtors and insiders may take certain actions intended to disrupt the sale. So for example, an insider or the debtor may attempt to intimidate the stalking horse bidder or other potential bidders. They may refuse to grant the buyer access to the property, asset, or necessary documents and information. They may refuse to vacate the property after the sale has occurred in the instance of where they're currently occupying the asset. May cause damage to the property after the sale is approved but before closing and while still in possession of the property. So for example, they may start taking out fixtures or other pieces as part of the overall sale package. And while there are ways to compel compliance and stop disruption when it arises, these remedies require court intervention, which means more delay, more lawyers, and higher costs. The seventh category of risks we've identified involves the risk of an appeal and the potential for a reversal. And this arises because, as with any court proceeding, the court's order approving the sale is subject to appeal, which result to delay of the estate and sometimes to the buyer. In connection with filing an appeal, a prudent appellant a stay pending appeal, and if the stay pending appeal would bar the sale from going forward until final resolution of the appeal. Now, as while an appeal is pending, even if the order pending appeal or if the request for stay pending appeal. So that request that the bankruptcy court make a good faith finding under Section 363M of the essentially is a finding that the parties acted in good faith and that the sale is the product of an arm's length transaction, which then usually, once reviewed by the appellate court, they will not upset the sale. And another way to minimize the consequences of an appeal is to try to close the sale as soon as possible while the appeal is still pending, assuming no stay pending appeal has been issued, which then, if successful, could actually render the appeal moot and subject to dismissal as moot. Now, the last risk we've identified for discussion today is the risk of successor liability. Successor liability really is the legal theory by which claims can be asserted against a buyer of an asset, even in the absence of any express agreement to assume those liabilities. The Bankruptcy Code in Section 363F, as Asa mentioned, recognizes the need for finality of sales by allowing a sale to move forward free and clear of liens, interests, claims, and basically to walk away with a free and clear asset. However, there is a tension between the legal principles of successor liability and the goals of the 363 sale process. So generally, a buyer does not assume the seller's liabilities unless, for example, the buyer expressly assumes those liabilities, the transaction constitutes a merger or consolidation, the buyer is a mere extension of the seller, or the transaction amounts to a fraudulent or collusive attempt to avoid the seller's liabilities. However, successor liability claims have arisen in connection with products liability, ERISA, tax and environmental claims. And in such instances, case law interpreting Section 363F has only resulted in confusion. Some courts have held that no successor liability can ever be imposed because that would reduce the prices that the debtors would receive for their assets, while other courts have held that successor liability claims can never be extinguished by a 363 sale. So the takeaway here is that a free and clear finding does not necessarily act as an absolute bar against the imposition of future successor liability. But despite the uncertainty, there are things a buyer can do to manage and minimize potential successor liability claims. First, a buyer's best protection against successor liability is to build protections into the purchase agreement and sale order. So for example, a buyer should request that the sale order contain unambiguous language stating that the sale is free and clear of all claims, whether known or unknown, liquidated or unliquidated. The purchase agreement and order should include broad releases and provisions enjoining creditors from bringing actions against the buyer. If it is likely that substantial unknown claims exist, such as product liability or other tort claims, then the buyer may want the additional protection of having the debtor set aside a reserve to pay unknown tort claimants. If really unknown claims exist, then the buyer and seller may agree to a discount price in an amount to sufficiently offset the potential liability claims, which of course this isn't foolproof because it would be difficult to determine what an appropriate discount should be, but can be a provided benefit or an additional benefit if you want to move forward with the sale anyway. And a buyer can also ask that the court condition the sale approval upon including language eliminating successor liability in the order. So you may run into issues of enforceability under state law, but if it's enforceable, then the debtor would retain any kind of liability for future successor liability claims.
Okay, that brings us to the end of the presentation. I apologize if we ran a bit longer than expected, but thank you for joining us and for sticking around. We hope you enjoyed this and found it helpful. Should you have any questions or want more information, please feel free to reach out to either Jessica or me. Our contact information is on the final slide. Thanks, and we are signing off.